What I'm going to do this evening is speak about the Land Reform Scotland Act 2016. That Act came into force in March of last year, and it introduced with it various new rules in respect of agricultural tenancies, most of which arose from the work of the Agricultural Holdings Review Group. And some of those rules are now in force, some aren't yet in force, and what I'm going to do this evening is give a broad overview of the Act and tell you what's in force right now and what isn't in force yet and when it's likely to be coming into force. So we've already heard from Bob about the functions of the Scottish Land Commission and the Tenant Farming Commissioner, so I don't propose to say very much about that this evening, apart to point out the obvious mistake on the slide, which should of course read parts 2 and 3 of the Land Reform Scotland Act. That's where the rules and regulations in relation to the Land Commission and the Scottish Tenant Farming Commissioner are laid out. I should also say that my talk is in your pack, so there is a printed version of this talk for you to refer to afterwards. So there's no need to take particularly detailed notes as you're listening to me. So the sections in relation to agricultural tenancies can be found in Part 10 of the 2016 Act, and they are found in sections 85 to 123 inclusive. And what I hope you'll go away from this meeting this evening with is a clearer understanding of what is actually in force now, what's to come into force, and what the implications of the new rules are for those of you who are agricultural tenants and agricultural landlords. So, before I turn to look at assignation and succession to agricultural tenancies, just a word or two about what's to come into force but isn't in force yet. There are new rules about modern limited duration tenancies. There are new rules about repairing tenancies. There are new rules about rent review, all of which are to be introduced in the future but not quite yet. I'll have something to say about rent review slightly later in my talk. The other thing which is being introduced by the Act is the abolition of the need to register a preemptive right to buy on behalf of agricultural tenants in the Register of Community Interests in Land. At the moment, those of you who are secure tenants in 1991 Act tenancies have a right to register in the Register of Community Interests in Land, and on registration, what that does is means that if the landlord decides to sell the farm, the landlord must come to you and give you first offer before the farm is sold. But that right only arises at the moment if in fact you've registered your right in the register. That requirement is being done away with, so that so long as you're a secure 1991 Act tenant, the right to buy will arise automatically if the landlord decides to sell the farm. Now that's going to throw up a number of interesting problems, because not every secure 1991 Act tenancy out there is actually in writing. And there are quite a lot of arrangements, even now, which started off perhaps as grazing lets, or perhaps even a seasonal let of some sort to take a crop from land, where the tenant never actually moved off, remained in occupation, has offered up rent year on year, which the landlord has accepted. And often those circumstances will be enough in and of themselves, if they happened before the end of 2003 when the law changed, to create a secure tenancy in favour of the tenant without anything at all being in writing. So, if there is no written lease and there is an occupation arrangement like that, it's going to create an interesting problem when the landlord comes to sell the farm, because at that stage the landlord will have to approach the tenant. But a lot of those arrangements have jogged on from year to year with nobody being very sure of the basis on which the occupation is continuing. And some of them are in fact secure tenancies and some of them aren't. And I think what we'll see happening is that once the need to register your preemptive right to buy is done away with, landlords will take a closer look at all those sorts of arrangements to try and flush out what might be a secure tenancy, where the tenant might have a right to buy if the landlord chooses to sell, and those other sorts of arrangements which are more casual in nature, where the tenant doesn't have security. And certainly, if somebody's buying a farm, at the moment, it's an easy thing to do to check the register to see if somebody's registered a preemptive right to buy. At the moment, or after abolition of this requirement, there will be no register to go and check against, and therefore people buying farms will want to be very, very sure indeed that in fact there's not an occupier who's going to come out of the woodwork at a later stage and say, well, actually that farm should have been sold to me because I'm a secure tenant, because in those circumstances that tenant then has an absolute right to buy. So sales and purchases will become slightly more complicated, and there'll be a little bit more due diligence to do. What's also not in force yet, but which will be coming in due course, are the rules which will allow a tenant to apply to the land court for an order that the landlord sell the farm if the landlord is in a material breach of their obligations under the lease in a way which is in turn materially prejudicial to the tenant's ability to continue farming. And that's probably going to revolve around really serious issues to do with failure to replace and renew fixed equipment by the landlord and so on. None of that's in place yet, but will be coming into force over the course of the next year or couple of years. So that's what's not in force. What is actually in force? So to begin with, I want to have a look at the assignation and succession rules. These have been changed with effect from the 23rd of December last year, so that all assignations are lifetime transfers, which the tenant makes a lifetime transfer of their interest in the lease to a family member. That's an assignation. Succession is where a family member inherits the lease after the death of the tenant. So, turning to look at assignation first of all, what the Act does is create two classes of relative. There's a wider class of relative and there's a class of near relatives. Now that wider class of relative is really quite wide indeed. I've included the full list in my paper, but it includes people like, for example, spouses or civil partners of stepbrothers or stepsisters, or descendants of stepbrothers and stepsisters. So that's, and there are other permutations as well. So it's really extending the possible range of family members to whom a lifetime assignation of a secure agricultural tenancy can be made. Really quite wide indeed. However, and this is quite a crucial thing to come away from the meeting this evening with, the Act also creates a class of near relative. And the class of near relative is more restricted than the wider class which I've described. I'm not going to itemise them because you can see them on the slide and they're also listed in my paper. Now, why does the Act distinguish between that wider class of relative and near relatives? It does that because the grounds of objection which a landlord has in relation to a lifetime assignation differ depending on whether it's a relative from that wider class or a near relative. Where the relative is from that wider class that I've described, the landlord has a right of objection on any reasonable ground. However, where the assignee is a near relative, someone from that list, the landlord's right of objection is restricted to three particular grounds. And the restricted grounds of objection, which apply to near relatives only, are firstly, that the person isn't of good character. So, it's quite an extreme example, but a convicted axe murderer isn't a person of good character, or a fraudster, or something similar. Second ground of objection is that the person doesn't have sufficient resources, financial resources, to enable that person to farm the holding with reasonable efficiency. And that pretty much speaks for itself as well. The third ground of objection is one which goes to the skills and experience of the person to whom the tenancy is being assigned. If that person doesn't have the necessary skills and experience to be able to farm with reasonable efficiency, that will be a ground of objection on the part of the landlord. But, there is quite a large but. That ground of objection can be avoided by the assignee if they sign up to a full-time course in agriculture which will give them the necessary skills and experience, and if they make arrangements for the farm to be farmed with reasonable efficiency during the time that they're acquiring those skills and experience by attending college or whatever the case may be. So although that on paper at least seems like a fairly formidable objection to somebody who isn't experienced in agriculture, it is one which has a relatively straightforward get around, if you like. But it's one which requires a considerable degree of commitment on the part of the family member to whom the assignation is being made. Now, the rules in relation to succession to agricultural tenancies have also been changed. And once again, the Act creates a wider class of relative and a class of near relative, those two classes being identical to the classes of relative which we've just discussed for the purpose of lifetime transfers. And once again, the Act provides that if the person who is inheriting the tenancy is from that wider class of relative, the landlord has a ground of objection on any reasonable ground. Whereas if the person who is inheriting the tenancy, someone from the list which I showed you earlier, the landlord's grounds of objection are restricted to the three grounds which I touched on earlier. Character, financial resources, and skills and experience. But once again, the skills and experience test can be gotten round, if you like, by someone going off to take a course to acquire those necessary skills and making arrangements for the farm to be farmed with reasonable efficiency during their absence. So, the only safe course of action from a tenant farmer's point of view when planning either a lifetime transfer of the tenancy or indeed planning succession to the tenancy after their death is, if at all possible, to choose a relative who falls within the near relative class, because the grounds of objection, as we've seen, are very restricted and in most circumstances should be possible to get round. Whereas if the relatives from that wider class, the landlord can object on any reasonable ground, and any reasonable ground could be quite wide indeed and might well include circumstances particular to the landlord. The landlord has a reasonable need to get that farm back for some particular purpose of the landlord's own. Not a ground available to a near relative, but it is a ground of objection available to a relative from that wider class that I've described. Quick word on procedure in relation to inheriting an agricultural tenancy. There are very strict time limits which apply, none of which have been changed by the Act, but I think it's always worthwhile reminding people about what those time limits are. Where the tenant is permitted by the lease to make a formal bequest of the tenancy in their will, then the person to whom the tenancy has been bequeathed in the will has got to give a notice of acceptance to the landlord within 21 days of the date of death. And I think most people are familiar with that kind of urgent need to get a notice to the landlord. Once again, there's a fairly large but, however, and that is that most leases, certainly every written lease, will actually exclude the tenant's right to make a formal bequest of their interest in the tenancy in their will. In which case, the tenancy cannot be inherited as a result of the tenant's will. That doesn't mean that the tenancy can't be inherited, because there's a whole different procedure which then applies to the succession, and it involves the tenant's executors as part of the administration of the estate, confirming to the tenant's interest and then making a formal transfer of that interest to a suitable family member, hopefully somebody from that list of near relatives. Now, the executors have a year from the date of death to go through that process. So that time limit is quite wide or quite long, and in most situations in which I deal with, the lease can only be inherited by use of that longer procedure. And in fact, the only tenancies which are really capable of being passed on by the tenant in his or her will are tenancies which aren't in writing, the sort of situation which I described at the very outset of my talk. The person who has the tenancy transferred to them by the executors then has a strict period of 21 days to serve a notice on the landlord that they have in fact become the tenant. So those time limits haven't been changed by the 2016 Act, but if they're not observed, the tenancy will lapse. There are lots of agricultural tenancies out there which have fallen by the wayside because the families and their advisors hadn't appreciated the time limits which were operational. And I had an example in the Land Court earlier this year where that happened. So remember the time limits, take advice, for goodness sake. I'm going to have a look now at landlords' improvements and then diversification. One of the new procedures introduced by the 2016 Act was in relation to landlords' improvements. Where a landlord proposes to carry out an improvement on the let farm, it's now necessary for the landlord to serve an improvement notice on the tenant. And that improvement might be a new building of some sort. The improvement notice has got to be served at least 2 months in advance of the carrying out of the improvement, and it must explain why the improvement is necessary for the efficient management of the holding. The tenant then has a right to object, again within 2 months of receipt of the notice, and if the landlord wants to press the issue, the landlord must then apply to the Land Court for an order allowing the improvement to go ahead. Now, the landlord can completely disregard that procedure and just carry on with the improvement anyway, but the consequences of doing that are that the improvement can't be the subject of rent in a future rent review and can't be taken into account in any argument with the tenant about whether or not the tenant's fulfilling their obligations to farm the farm in accordance with the rules of good husbandry. The tenants improvement or landlord's improvement procedure doesn't apply, however, where the improvement is being carried out because it's necessary to protect public health or it's necessary to prevent a danger or potential hazard to the public, or it's to enable the tenant to comply with the requirements of the Animal Health Welfare Scotland Act. So unless those restricted circumstances apply, the landlord, if he wants or he or she wants to be able to charge rent on the improvement, they must serve a landlord's improvement notice in advance. And it's often occurred to me, I wonder if somebody will be standing up in 10 years' time addressing an audience like this and explaining to them the new rules about the amnesty procedure for landlords' improvements. I suppose time will tell. Diversification. Most of you will be familiar with the idea that an agricultural tenant since 2003 has a right to diversify away from agricultural activity by following a set procedure. And that procedure is the service of a notice on the landlord, telling the landlord 70 days in advance that the tenant's going to carry out a diversified activity, what the activity is, what land or buildings are going to be used, and how that activity is going to be financed and managed. In turn, the landlord has a right to serve a notice of objection and has a right to call on further information, and on receipt of that further information has a right to call on further information, and also has a right ultimately to object. If the landlord objects, it's then for the tenant to apply to the Land Court for an order approving the diversification. So that's the procedure as it was prior to the 23rd of December. That procedure has been streamlined and turned on its head to a certain extent. The tenant is still required to serve a diversification notice at least 70 days in advance of the diversification activity. Still got to explain what it is that the diversification is going to be, how it's financed and managed, what land and buildings are to be used for it. The landlord also retains the right to ask for further information or make an objection, but the landlord only has one bite of the cherry. On asking for further information and the tenant replying, the landlord must then either agree that the diversification goes ahead or object. And if the landlord objects, it's for the landlord, not the tenant, to then make a subsequent application to the Land Court to uphold the objection. So the onus shifts from the tenant who wants to carry out the diversification to the landlord who wants to stop it. So now the Tenants Amnesty. I thought I'd talk a little bit about the formal legal procedure and some common misconceptions which exist about it. For those of you who are interested in actually reading the formal technical detail of the amnesty, you can read them in sections 112 to 118 of the 2016 Act, or I suppose you can rely on my paper in the back of your packs. The amnesty procedure started on the 13th of June, so last month. The important thing to remember is that it's time limited. It lasts for a period of 3 years and it will expire on the 13th of June 2020. So I think the catchphrase of this evening's meeting is use it or lose it. I mean, that is literally the case. If a tenant doesn't avail themselves of the amnesty procedure and those 3 years come and go, the right to be able to qualify something for compensation at the end of the tenancy under the amnesty procedure will be lost. And if there is an opportunity to qualify something for compensation, why on earth would somebody allow that to happen? So it is very much a case of use it or lose it. Another thing to take away from this evening's meeting is that it only applies to improvements carried out and completed prior to the 13th of June, so that improvements started after the 13th of June will not qualify for the amnesty procedure. So it's not a case now of thinking, well, I can carry out my improvement and I don't need to worry about serving a notice on my landlord because, of course, I can use the amnesty. That's a fatal misconception. For improvements which you are carrying out subsequent to 13th June, it's still necessary to go through the formal procedure of serving an improvements notice on the landlord if it's an improvement requiring notice. And that would typically be putting up a new building or making a substantial alteration to a landlord's building. The other thing to understand is that none of this is about valuation or payment of compensation at this stage. The amnesty is in order to qualify something for compensation at the end of the tenancy. It's not concerned with how much that compensation might be. There's no need to carry out a valuation process as part of the amnesty procedure, and there's certainly no question of a landlord having to pay compensation for an improvement which qualifies, except when the tenancy comes to an end in due course. That's the whole point of the amnesty procedure. So, I recommend to you very highly indeed the Tenant Farming Commissioner's recommended code of practice in relation to the use of the amnesty procedure, and I think the hope and expectation is that in most cases it'll be possible for the landlord and tenant to actually sit down and agree pretty much all of this stuff. But where that's not possible, there is a formal process to be gone through. And that process is initiated by the tenant serving an amnesty notice on the landlord. And the amnesty notice lists all of the tenants' improvements which the tenant thinks should qualify for compensation at the end of the tenancy, but don't at the moment. And the amnesty notice must also explain why it's fair and equitable for the landlord to have to pay compensation for that improvement at the end of the tenancy. The classic scenario will be an improvement which required notice to be served on the landlord in advance of the improvement being carried out. And that would be, for example, a new agricultural building. The rules since 1949 have been that the tenant must serve an improvement notice on the landlord, notifying the landlord about what it is the tenant's going to do by way of improvement, and roughly how much it's going to cost. The landlord has a right to object to that improvement, and if the landlord objects, the tenant must then apply to the land court for an order approving the carrying out of the improvement. Now, in past years, it was very common indeed, for the tenant to carry out an improvement without giving notice at all, or maybe after a conversation with the tenant's factor, or indeed with the landlord himself or herself, and there's some informal understanding that, yes, of course, please carry on with the improvement. The problem about that is that none of it's in writing, it's not formally documented, it hasn't followed the procedures in the Act, and therefore, prior to the amnesty procedure, that improvement would not qualify for compensation at the end of the tenancy, sometimes with very harsh results. And it may be that there's no element of bad faith in respect of any of that, because the conversation between the landlord and the tenant about that new building took place 2 or maybe even 3 generations ago, and nobody now alive actually remembers the exact circumstances in which it was carried out, except that it can be demonstrated that formal procedures weren't followed. So the amnesty procedure gives you the opportunity to qualify improvements of that nature for compensation at the end of the tenancy. There are some important restrictions on the right to use that procedure, however, and they include where the improvement was one which required not just giving notice to the landlord, but the landlord's consent in advance. Historically, the Agricultural Holdings Acts have always distinguished between improvements which required advance express consent from the landlord before they were carried out, improvements which required notice to be given to the landlord before they were carried out, and improvements which don't require consent or notice. Now, the problem which arises is that as the Agricultural Holdings Acts have evolved over the last almost now 140 years, the definition of notices which required consent, improvements which required consent, improvements for which notice had to be given, and improvements for which neither notice nor consent were required, have changed. So that if you have, for example, a building which was erected, let's say in the very early 1930s or the 1920s, and there are still some current tenancies out there, and there are still circumstances where that will be the case, erecting a building at that stage was a matter which required the landlord's consent in advance. And so that improvement can't use the amnesty procedure, because at the time it was carried out, it required the landlord's consent. Post-1949, of course, the rules changed, and putting up a building required notice but not consent. So there are some peculiarities like that which you have to watch out for, and which would hopefully be flushed out as you go through the process of identifying what are improvements which you can avail yourself of the amnesty about. The other thing which you've got to watch out for is that if the tenant served a notice and the landlord objected to the carrying out of the improvement, let's say it was putting up a new building, and the tenant didn't then follow through with an application to the land court, you can't use the amnesty procedure to qualify that improvement for compensation. Likewise, if the tenant served a notice, the landlord didn't object, but the tenant then carried out the improvement which was substantially different to the one which the landlord was notified about, you can't use the amnesty procedure. So the tenant gave notice for a shed, I don't know, 60 by 120, and then actually put up a building twice that size. That's materially different to the improvement which was notified, and therefore you can't use the amnesty procedure to qualify that improvement for compensation. Now that's going to give rise, I think, to some very harsh results in practice, because you can imagine a hypothetical situation where we have Farm A and Farm B. They're neighbours. They march together. They're both tenants. They're both on the same estate. They put up the same agricultural building each in the same year. Tenant A, let's call him, knows a bit about the law and thinks, well, I want to do this properly because I want to qualify my new building for compensation at the end of the tenancy. So he serves his notice, or she serves her notice. The landlord objects, but the tenant just carries on regardless, doesn't go anywhere near the land court, thinks that's all too expensive, just goes ahead and puts up the building. Tenant B is more lackadaisical and either doesn't care or is genuinely ignorant that there are any legal requirements at all. So tenant B just carries on and erects the same building without giving notice to the landlord. Tenant B can use the amnesty procedure to qualify that building for compensation. Tenant A is stuck because tenant A went halfway down the correct road but didn't follow it through. So tenant B, who ignored or didn't know about the rules, gets compensation. Tenant A, who at least was aware but didn't understand them properly, doesn't get compensation. Although perhaps tenant B, not knowing anything about the rules about giving notice, won't know anything about the tenant's amnesty either, but we'll wait and see. So there are some odd effects about the amnesty procedure, and it's not necessarily straightforward. And I think that anybody thinking about going down this road would be best advised to take some professional advice in advance. And I think that it would actually represent value for money to get not only legal advice, but also some practical land agency advice as well. Now, of course, Bob has already touched on the possibility of reaching an amnesty agreement with your landlord. You can sidestep the whole amnesty procedure by having a discussion with the landlord and reaching an amnesty agreement to qualify for compensation, anything you like, really. But the point about an amnesty agreement is that it's an agreement and it's not something which is obligatory. If there's no agreement between landlord and tenant, and if in fact they're at loggerheads, then you'll have to use the formal tenant's amnesty procedure. Also, the amnesty applies to tenants' improvements which would currently qualify under the current definitions of improvements. And there are some modern improvements which don't qualify for compensation at the moment. And the classic example of that is slurry storage. It's not listed in the list of improvements under the Act, and therefore you cannot use the amnesty procedure to qualify for compensation, something which doesn't get compensated for at the moment because it doesn't fall within the list of relevant improvements. Bob touched on some grey areas, and I thought I'd just give my take on them. So what you're about to hear is opinion only, because of course there are some areas where it's possible to interpret the Act in different ways, and I suppose ultimately somebody might slug it out in the land court to find out who's right and who's wrong. Bob mentioned write-down agreements. Prior to 2003, it was possible for a landlord and tenant to agree that where the tenant was proposing to carry out an improvement, the value of the improvement would be written down over a period of time to a nominal figure. usually £1 or something similar. Now, those sort of agreements were prohibited from 2003 onwards, but where the writing down agreement was entered into prior to 2003 and where the writing down period had actually ran out prior to the law changing in 2003, there's a pretty good argument that that improvement won't be the subject of the amnesty procedure, because the test that the land court has to apply is it fair and equitable for the tenant to get compensation? And the land court may well take the view that if the landlord and tenant entered into a formal binding contractual agreement between themselves, agreeing that the value of the compensation would be written down to a nominal figure, and all of this took place prior to the law changing in 2003, then that won't be something that can be the subject of the amnesty procedure. Now, you'll be hearing from Tom shortly. Tom mentioned to me this evening that Sir Crispin Agnew QC, who many of you will have heard about, he's a leading advocate in the Scottish Land Court, takes a different view. So perhaps at some stage Sir Crispin and I will be arguing about that in the Land Court. I have a particular view about it. The Land Court will ultimately determine who's right and who's wrong. And sometimes Sir Crispin's right, sometimes I'm right. So we'll have to wait and see about that.
That's maybe one for Bob to fund.
Reasonable rates, Bob. Post-lease agreements were another grey area. Post-lease agreement is an agreement whereby the tenant takes on the renewal and replacement obligations in respect to the fixed equipment on the farm in a 1991 Act secure tenancy. The usual rule is that the landlord provides the fixed equipment in a thorough state of repair, the tenant repairs and maintains it. When it wears out through fair wear and tear, the landlord is obliged to replace it or renew it. A post-lease agreement passes all of that obligation from the landlord onto the tenant's shoulders. So not only does the tenant have to repair and maintain, the tenant also has to replace and renew. So if the tenant has actually had to replace or renew fixed equipment under a post-lease agreement, is that work subject to the amnesty procedure? Well, in one view, it's not, because it was work which the tenant was obliged to do under the post-lease agreement. I think, however, that where the tenant has provided an element of betterment, then that element of betterment would represent a tenant's improvement and should be subject to the amnesty procedure. And I think a clear-cut example of that would be a new building. So the landlord has provided a traditional steading range, because this might be a tenancy which is 40, 50, 60, 70 plus years old. That steading range has failed through fair wear and tear, and it's the tenant's obligation as a result of a post-lease agreement to actually replace and renew it. But the tenant replaces it with a modern steel-framed building of significantly greater capacity than the old traditional steading range. There's a substantial element of betterment in that work, and there's no reason, so far as I can see, why the tenant shouldn't be able to use the amnesty procedure to qualify that betterment for compensation at the end of the tenancy. Another thing to touch on, I think, was the farmhouse. The farmhouse is an item of fixed equipment provided by the landlord. It's reasonably necessary for the efficient management of the holding. So in principle, tenants' improvements to the farmhouse to bring it up to modern habitable standards, it should qualify for the amnesty procedure. So that would be obvious things like double glazing, central heating, modern sanitary systems and so on. I can't see why any of that wouldn't qualify using the amnesty procedure. Where tenants will begin to struggle, however, is if they've tacked on some huge glass conservatory onto the side of the farmhouse. It's difficult to see why that would be reasonably necessary for the efficient management of the holding. So that sort of work is unlikely to qualify as an improvement under the amnesty procedure. So, moving on, and moving away, in fact, from the Tenants Amnesty, I thought I'd say just a few remarks about rent and the new rules about relinquishment. Most of you will be aware that secure tenancies are subject to an open market, well, it's a qualified open market rent review test at the moment. So the question is, what would any particular farm fetch on the open market if offered for rent, and that is the figure that should be fixed at the rent review date. There are restrictions on that, of course, to do with scarcity of supply and tenants improvements and so on. The open market test is being done away with, and it's being replaced by a fair rent test. A fair rent test which relies principally on the productive capacity of the holding. And it's an attempt to reach a more reasonable rental figure for any particular farm. Now, the provisions are fairly complex. They're the subject of rent review testing work at the moment, and that work's been carried out by a consortium which involves Savills, myself, and a land agent called Watson Bell. And that's a little bit, I suppose, like a conglomerate of gamekeepers and poachers. And that's all about trying to bring balance, fairness and reasonableness to the whole thing. So that work's taking place at the moment. It should be completed within the next 2 or 3 months. As a result of that rent testing work, Scottish Government will then iron out the fine detail within the Land Reform Act and will introduce the new rent review rules probably during the course of 2018. The rules won't be retrospective, however, so rent review notices which are served any time up to the bringing into force of the new rules will still be determined under the qualified open market test. A couple of other points about the new rent review procedure. The procedure is front-loaded. At the moment, if you want to serve a rent review notice on your landlord or on your tenant, you pretty much just have to send them or her a letter saying, I wish to review the rent with effect from such and such a date, as long as you give a year's notice and it's against an anniversary of the tenancy. The new rules will require the rent review notice to set out what you think the rent should be and the detailed reasons, relying on the productive capacity test, of why the rent should be that particular figure. So that's going to require quite a lot of preparation in advance of serving the notice in a way which I don't think is going to help lay people particularly use the procedure themselves, because there will be technical requirements. It'll be difficult to get right. And what is at the moment a simple process will become quite a complex, detailed process. The other thing is that at the moment, the rent review notice has got to be served on the same timescale as a notice to quit. So you've got to give not more than 2 years' notice, at least 1 year's notice, and you've got to serve it on the anniversary of the tenancy. Typically the anniversary will be the 28th of May or the 28th of November in any year. So as we stand here on the 18th of July, if I want to review the rent in respect of a tenancy which has an anniversary date of the 28th of May in each year, serving that rent review notice, the earliest I can serve it against is the 28th of May 2018, because that's less than 2 years away and it's more than 1 year away. However, the new Act does away with that and allows someone to serve a rent review notice on at least a year's notice against any date that they like. So standing here today, 18th July, I could serve a rent review notice on that farm which has an anniversary of 28th May against the 19th of July next year. The only caveat to that is that there's got to be a clear gap of 3 years since the date that the last rent review was carried out. But as I say, these new rules won't be enforced until next year at the earliest, and they won't be retrospective. So rent review notices served at any time up to the coming into place of the new rules will be under the current procedure. Just a quick glance at relinquishment. There's a little bit of confusion about relinquishment because people confuse it with assignation. What the rules about relinquishment have to do with are the ability of a tenant in a secure tenancy to offer to sell the tenancy back to the landlord, and if the landlord doesn't wish to buy it, the tenant is then able to sell the tenancy to a new entrant or a progressing farmer, and sell the tenancy as a secure tenancy so that the new entrant or progressing farmer who's buying that tenancy will become a secure tenant in due course. So the tenant isn't able to use that procedure, however, until they've first of all given a notice to the landlord, and the landlord has a right to buy the tenancy back at a set valuation formula set out in the Act. And what the Act does is say that you've got to calculate what the open market vacant possession value of the farm is. So what would that farm sell if sitting vacant, placed on the market now? What would somebody pay for it on the basis that they were able to move into it immediately and start farming? The Act then says that you've got to calculate the value with a sitting tenant, and the value with a sitting tenant will always be less than the open market vacant possession value. Now, the valuation formula says that the valuer mustn't take into account anybody that the tenant would be able to assign or transfer the tenancy to on death. So I spent a little bit of time talking about the wider class of relatives and near relatives and so on. The valuer doesn't take account anybody within that class. So the valuation formula looks at the actual individual tenant and effectively asks, when is that tenant either physically going to have to retire from the farm because they're no longer fit, or in fact, when are they going to be carried out the front door in a wooden box because they've passed away. So it's got to do with the longevity of the tenant. And you can see pretty easily, I think, that if we've got an 80-year-old tenant, then the landlord has a reasonable expectation that that tenancy would come back to them within a reasonable period. Whereas if the tenant is a 30 or 40-year-old person, they could conceivably be in that tenancy for another 30 or 40 years, and therefore that discount will be greater. In any event, whatever the open market vacant possession value is and the discounted value, what the landlord has to pay is half the difference. And the landlord has also got to pay compensation for tenants' improvements and so on. It's only if the landlord decides not to pay that sum that the secure tenant can then sell the tenancy on the open market. And the class of potential purchasers is restricted to new entrants and progressing farmers. Scottish Government will be defining in due course who a new entrant is and who a progressing farmer is, but they haven't done so yet. But interestingly, there's no restriction on the price which the new entrant or progressing farmer will have to pay. So it does appear that that will be purely an open market situation, and it will be whatever it will be, I suppose. And it'll be interesting to see what sort of market actually develops. I suspect that most landlords who are able to do so will exercise the right to buy the tenancy back, because there is a valuation formula and it will never become available for the tenant to be able to sell. I think if a tenant was lining themselves up to be able to use that procedure in due course, one of the things that they should certainly do is use the amnesty procedure to make sure that all of their improvements can qualify for compensation. Because if they're ever able to sell the tenancy, one of the things that a purchaser is going to be very keen to learn about is, well, if I pay X for this, what am I guaranteed to get back by way of a return, because I can claim compensation for tenants' improvements if the lease ever comes to an end. There may be an opportunity for a bit of advanced planning as well, because if a family are just going to come out of farming, but it's the wrong generation who is the tenant, then there might, and I must stress this, it's might, because we would have to wait and see what the detailed regulations say, but there might be a case for transferring the tenancy from an older family member to a younger family member in order to maximise the discount and therefore the price that a landlord would have to pay. I think that would give rise to some interesting conversations within the family, however, and there might have to be an agreement, because dad or mum doesn't necessarily want to transfer the tenancy to son or daughter, who then promptly sells it and disappears with the loot to the Caribbean or wherever. So, relinquishment isn't in force yet. It may be coming into force as early as this year, certainly during the course probably of the first part of next year. It may be an opportunity which will suit some tenant farming families out there. So, ladies and gentlemen, I'll be very happy to answer questions. The substance of my talk is in my paper, however, and thanks very much for your attention.